Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And in this video, we are going to look at construction accident jury verdicts in New York. And not just any jury verdicts, but we're going to look at the highest jury verdicts where the jury returned millions and millions of dollars in compensation. These are the highest verdicts in New York. And we want to examine this in order to determine what are the driving factors? What are the catalysts? How do these lawyers hit for big numbers? And what do the clients have to get these big multi-million-dollar results, right? So let's get into it. Here's the first case, and this is a case from the Bronx. And I'm sorry, this is a case from Westchester. And this is a case that happened in June of 2023. And what happened was an individual was involved in an accident as a construction worker when a heavy piece of fencing fell on him, and he suffered neck and left shoulder injuries. And he was walking along a sidewalk next to a construction site, and he allegedly suffered injuries that included the neck and lower back herniated discs, as well as bulging discs. And he had radiculopathy, which is the radiating pain, when you have pain, say, in the neck, and it'll travel to the hands. And if you have it in the lower back, it'll travel down to the legs. And that's what he had. And he had left and right knee medial meniscus tears, a left knee ACL sprain, left shoulder subacromial impingement. So he had a lot of different injuries. And I guess because this fencing, this heavy portion of fencing just fell on him, he was walking, he wasn't at fault. And so the verdict was for over $11 million. And this, like I said, just happened in June of 2023. So it was one of the recent ones. And here's another case. This case is in Brooklyn, in Kings County. And this particular case, the date of incident was December 14th of 2016. The lawsuit was filed in February of 2017, and the verdict came down in December of 2022. And so what happened in this case was a construction worker fell about 10 feet from a set of temporary wooden stairs while working on a 3-story extension of a 2-family residence. The property was under construction by his employer, a construction company. And according to court documentation, this employer was the general contractor for the entire project. And it subcontracted masonry work to a third-party defendant, which was a design corporation. And the plaintiff reported injuries of spinal cord injury resulting in quadriplegia with a neurogenic bladder and bowel. And the plaintiff also allegedly suffered multiple vertebral fractures and claimed he was unable to work and suffered a quality of life loss. And the plaintiff contended that the defendants were in violation of the New York State labor law, which is Section 240, 241, and 200, as well as the industrial code of the state of New York. Now, the plaintiff claimed that the defendants were negligent and that they failed to provide him with a safe place to work, failed to take reasonable safety and suitable precautions for the safety of persons, utilizing the subject staircase and providing a defective staircase without handrails. So that's a building code violation as well. And the plaintiff also claimed that the property contained a nuisance and trap for the unaware. The defendants denied liability and claimed they were entitled to the 1- and 2-family building exclusion to the labor law, and claimed that the wooden ladder at issue was built by the plaintiff and a coworker, making the plaintiff negligent if it was not fitted with handrails. So they basically said that you built this, you're at fault, and also the 1- or 2-family owner-occupied exclusion, which means that, look, if I'm an owner and I have a small residence and that residence is under construction, that's an exemption. I'm excluded from the labor law. And you could sue a GC for like a commercial construction, but you can't sue for a 1- or 2-family construction. And the theory behind that is because, it's a smaller owner, and unless that owner is directing and controlling the work, the method and manner of the work. Then you could still sue them. But if they're not, you can't sue the owner of a 1 or 2 family residence. So what happened in this case? You guys want to guess? Do you want to guess the verdict? Okay, the verdict was $46,250,000. So it was a really big verdict. And I know the lawyers involved, they're from Manhattan, very good lawyers. And I see the judge. I've had cases before this judge, both for trial and motions. He's a very smart judge. And yeah, I'm familiar with, and I actually know the expert that they used. They used an engineering expert that I've also used on many cases. So yeah, overall, an amazing result, $46 million. I don't know if that was sustained on appeal. I don't know if they have that kind of money, that kind of insurance. Probably the case settled. We could probably do a little research or ask around to see what ended up happening. Okay, the next case is also in Brooklyn. And this case is a work accident on the construction site. And what happened here was a 60-year-old plumber, and he said that he fell from a ladder while working at a construction project at a site owned by the defendants and developer. So there's a defendant landlord, and there's also a defendant developer. And according to the plaintiff, he was performing repair work on an overhead plumbing system of a new residential building after the pipes froze. And the plaintiff reportedly suffered left calcaneus and ankle fractures, which required fusion surgery and rendered him unable to obtain gainful employment. The plaintiff filed a motion for summary judgment under the labor law 240, known as the scaffold law, against the defendant premises owners, claiming the A-frame ladder that he fell from was improperly secured and defective, and that the defendants failed to provide him with proper and adequate safety devices to protect him in the event of a fall. The defendants objected to the motion, arguing there were triable issues warranting a jury decision at a trial, as there were material issues of fact that remained unresolved. And the defendants argued there was no proof that the ladder was defective and noted the intent of the scaffold law was not to make a defendant an insurer of the workplace when a worker loses his or her balance. Now, it doesn't say here, it just says he filed a motion for summary judgment. It doesn't say what the decision was, but it does say that there was a verdict. Okay, let's see here. So this case, the date of filing, by the way, was March 10th of 2017. I'm sorry, that was the date of incident. The date of incident was March 10th. That was the fall. Now, April 17th, just a month later, there was a date of filing when the lawsuit was filed, and the trial was November of 2022. So the case proceeded to trial, and there was a verdict. So the verdict was pain and suffering was $5 million. Future medicals were $502,000. Past wages, lost wages, were $150,000. Future lost wages were $160,000. So the total amount was $5,812,000. So it's a pretty good verdict, pretty high verdict for this kind of injury. So it was a good job by the plaintiff's attorney. And this was in Brooklyn. Now, the next case was also in Brooklyn. And this case involved a plaintiff who was performing demolition work at a construction project at a property owned by defendants as landlords, an LLC. And the plaintiff said he was carrying a bucket of debris to a dumpster and fell on water, ice, and snow in front of the dumpster. The plaintiff reportedly suffered injuries to his neck, back, left shoulder, left forearm, and right knee. The plaintiff asserted negligence in allowing the premises to become and remain in a dangerous condition, allowing him to work in an unsafe workplace and also failing to take suitable precautions. He also asserted violations of the labor law section 200, which is the common law, as well as section 240, which is the height, the gravity law, right, falling from a ladder or scaffold where the plaintiff falls, and 241.6, which is the industrial code section where they violate a safety rule. So the defendant denied that the plaintiff was working at the site on the date of the alleged incident. It also claimed that he gave conflicting accounts of how he suffered the injuries. So they basically said he wasn't even working there. That's an interesting defense. But anyway, so what was the amount? Let's see if you guys could guess it. The amount was a total of $9,460,000. And it was broken down as 2 million for past pain and suffering, 300,000 for past medical expenses, 110,000 for past lost wages, 5 million for future pain and suffering, and the jury awarded that for 39 future years. 1.5 million for future medical expenses, also for 39 future years, and 550,000 for future lost salary or earnings, and that was for 25 future years. Doesn't say the plaintiff's age here, but I'm assuming he was a young guy here, 40 more future years of work ahead of him. But that was a great result, 9 million. And I know the plaintiff's lawyer in that one too. He's a pretty good lawyer. We've had cases together. We've actually partnered on a few cases in the past. Okay, let's see the next case. The next case is in Queens. And this one involved an adult male construction laborer who suffered disc herniations at C2, C3, and T10 to T11, bulges at C6, C7, and L3, L4, with radiculopathy and chronic pain syndrome, a right wrist sprain strain with numbness and tingling, a left hip sprain strain, and a left knee medial meniscus tear with a 35-pound bucket of tools fell on him as he was lying on the floor on his right side, soldering a drain line in the boiler mechanical room on the 22nd floor of 30 Rockefeller Center, a work area managed by general contractor defendant, LLC, and owned by the defendant, LP, which is like a large property company. Plaintiff contended the defendants were at fault under the theories of negligence and statutory liability for failing to provide a safe place to work and properly coordinate construction activities, specifically by failing to provide adequate lift and overhead safety equipment, failing to properly inspect and secure the work area, and failing to comply with sections 241 and 200 of the labor law and Rule 23 of the Industrial Code. The defendant disputed the nature and extent of the injuries, arguing that the cervical and lumbar bulges and herniations and the left knee meniscus tear could not reasonably be attributed to the accident. The plaintiff's award, okay, they're talking about how the award was broken down. But before we get to that, what do you guys think the amount was? It was a total jury verdict of $11,700,000. So a really nice jury verdict for the plaintiff. And it was broken down as 8.1 million for compensatory pain and suffering, 1.5 million for future medicals, 200,000 for past lost wages, 600,000 for future lost wages, and the total compensatory award was 10,400,000. And in addition to that, there was a loss of services claim for the spouse, for the wife, and then that was 1.3 million. So the total was 11.7. So that was a very good result, I would say, especially given the injuries, because I don't see them mentioning like the surgery. I guess I'm assuming there were surgeries. They're not mentioning all the surgeries in the write-up. They're just saying the body parts like C2, C3, T10, T11. So that's an excellent result. Here's a case that was in Brooklyn. And this one basically involved an employee of a contracting company. He was hired as a subcontractor at a construction project. And while he was performing work at the premises, a scaffold collapsed, causing him to fall. So he was on the scaffold. And he filed a lawsuit against New York City and also the owner of the property, asserting the defendants were negligent in the ownership, operation, and supervision of the premises, and also the labor law 240, 200, 241.6, and Rule 23 of the Industrial Code. The plaintiff sought damages for medical expenses, lost earnings, and pain and suffering. Now, it doesn't say too much. It just says he reportedly suffered injuries. It doesn't say what his injuries were. This one would be kind of hard to guess. It doesn't say anything. But this one was for $6,400,000 $683,922. And it was broken down as $2 million for past pain and suffering, $322,000 for past lost earnings, $2.3 million for future pain and suffering for 37 years, $569,000 for future lost wages for 5 years, and $297,000 for future loss of Social Security retirement income for 10 years, $1,051,000 for future medical expenses for 36 years, and $100,000 for future medical expenses. Interesting. Why would it be twice for future medical expenses? I don't know. Maybe the write-up. This write-up doesn't seem very good because it's very general. Like, for example, for injuries, it just said he reportedly suffered injuries. I mean, that's about as general as you can get. I don't think you can get more general than that. So yeah, a lot of it depends on the write-up. But usually, these services do a good write-up, but this one maybe was a little bit lacking. Okay, here's a case in Queens, and this one involved an adult male bricklayer where he claimed that he suffered a traumatic brain injury with post-traumatic seizures, bilateral subdural intracranial hemorrhages, edema, and cranial pressure, which rendered him unable to care for himself, resulting in placement in a long-term care facility, as well as fractures across the calvarium, non-displaced fractures of the parietal bone, reactive thrombocytosis, respiratory failure, right pleural effusion, facial trauma, tongue laceration, when he was working on an elevated platform scaffold at a construction project where the defendant, a Holmes Company, LLC, was the general contractor. The platform collapsed and he fell to the ground, landing on his head. The plaintiff contended the defendant was negligent in failing to inspect, failing to erect reasonably safe scaffolding and platforms, failing to provide a safe place to work, and failing to supervise. And he also claimed the defendant violated Section 200, 240, 241.6, as well as the provisions of NYCRR and the New York Industrial Code. That's Title 23. And so the defendant denied liability and denied it constructed or supervised the construction of the scaffold. It argued that it had no notice of the scaffold's hazardous condition. Workers of the plaintiff's employer constructed the scaffold, and it exercised no control over the employer's workers. It claimed it was entitled to contractual indemnification from the plaintiff's employer. The court granted the defendant's claim for contractual indemnification against the plaintiff's employer and granted the plaintiff's summary judgment motion as to liability against the defendant. And so, what do you think the result was in this case? It was a verdict of $22 million. So a really great verdict. What happened was, 22 million. So what happened was the pain and suffering was 10 million. The future medicals were 8 million. So the total compensatory amount was 18 million. The loss of services was 4 million. And they also had agreed, they stipulated to past medical expenses of 1.3 million, which were added to the verdict amount. And the plaintiff's spouse filed a claim for loss of services. Yeah, that's for 4 million, like we talked about. So yeah, that's pretty good. That's really good. I mean, terrible that the person had like a life-changing brain injury, but a very, very excellent result by the trial attorney. Now, here's a case also in Brooklyn. This is from 2018. And what happened here was a male construction worker suffered multiple bulging and herniated discs for which he underwent spinal fusion surgery, chronic pain, permanent limitation of spinal and extremity function, radiculopathy, and permanent inability to work after an incident that occurred while he was removing molds from a previously poured concrete wall. It happened at a job site owned by general contractor defendant LLC, and in which another defendant, LLC, served as a project manager. And so he was bending over a 15-foot aluminum ladder propped against the wall and under which plywood had been placed by a coworker. And so the worker stepped on the plywood, causing the ladder to slide off the wall and strike his back. So he argued that the defendants were negligent in violating the labor law by failing to provide a safe place to work, allowing dangerous work conditions to exist, failing to provide proper and safe tools, and failing to supervise and inspect construction activities to prevent an improperly secured ladder to be and remain on the premises. Damages were disputed, and then it talks about the amounts. So the amounts here, the total was a total of $19,026,741. And it was broken down as $17 million for pain and suffering, $222,206 for past lost wages, $1.8 million for future lost wages. So the total compensatory amount was $19,026,741. And it says that the jurors awarded the plaintiff $15 million for future pain and suffering, $2 million for past pain and suffering, $931,000 for future medical and medically related expenses, including the cost of physical therapy, and $383,000 for past medical and medically related expenses, and more than $2 million for past and future lost wages. There's like a little, in the facts, it has the little last sentence was the award. So I just read that, but then on top, it has a different award, different amounts for the award as the damages breakdown in different categories. Okay, maybe let's do one more case. Here's a case. This one is also in Brooklyn. A lot of these cases are in Brooklyn. Wow, I'm in Brooklyn. I should be getting these cases. These are great cases. Look at these cases. Amazing. Amazing cases. Here's a case. An adult male carpenter construction worker allegedly suffered multiple herniated and bulging discs in his cervical and lumbar spine with radiating pain, radiculopathy, and traumatic myofascial pain syndrome after he was struck by an unsecured plank, causing him to fall from the scaffolding designed, constructed, and installed by the defendant, a construction company, and another defendant, an LLC, and he underwent cervical and lumbar spinal fusion surgeries, including laminectomy, facetectomy, discectomy with bone grafting and placement of hardware and biomechanical devices. And he suffered permanent pain, limitations of strength, motion, and function, and internal derangement of his right elbow in the fall. So the fall occurred on a job site at which the defendant, New York City Housing Authority, was a lessor. And plaintiff, he argued that the defendants were negligent for failing to provide him with a safe place to work and for violating the same sections we've been talking about: Labor Law 200, 240, 241.6, 240 of the New York State Labor Law, plus Rule 23 of the Industrial Code. It actually cites some of the codes, like 23-1.7, but I won't bore you with all the citations. And so the amount here, the final verdict amount, this was also, like I said, in Brooklyn. I know the judge, and I know the plaintiff's lawyer and also the defense lawyers on this case. And the result here was a verdict for the plaintiff in the amount of $15,228,000. And what happened here was, like we talked about, it was broken down as follows. So pain and suffering was $11.5 million. Past medicals were $270,000. Compensatory future medicals were $500,000. Past wages were $358,000. Future wages were $1.5 million. So other, it just says compensatory other. It doesn't say what the other, which category the other belongs to. So that's a little general. It says 1.1 million. So the total amount from the jury was 15,228,000. So that's a good one. And then, like, just looking over the list, there are other cases. There's another one here in Brooklyn that went for $6 million. There's one here in Westchester that went for $16 million. Wow, that must be a serious one in Westchester. So yeah, we could continue and do a few others. I'll make a little note here where I left off, and we could do another video. We don't want to make it too long, and we could do a few of these other ones. Yeah, I'll make a note here to continue, and we could do another video, talk about a few of these other ones later on. But thank you for joining us. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families If you need a consultation, just text me 347-566-9595. Happy to chat with you, text, or just give you a consultation. If you need help here in New York, I'm taking some cases. I'm trying to be selective and take serious injury cases where I could truly help the injury victims and their families. But if you fall into that category, give me a call. If you have a case somewhere else, what I do is I work with some of the best trial lawyers all over the country to help you. So I've been handling cases in Michigan, Florida, California, Texas, all over, so just feel free to text me. I'm happy to give you a free consultation. If you need a lawyer, either you have a recent case or you're not happy, the lawyer is not communicating with you, the lawyer is not doing anything, they're not a trial lawyer, you can consult with me. And what I'll do is I'll provide you with a consultation to a local lawyer. If I can, find the best local lawyer for you, then you could speak to that lawyer and see what you think. There's no obligation, obviously. You could choose to hire that lawyer or tell me, hey, I don't like that lawyer, I want another lawyer, and then I'll find you somebody else. So it's almost like we're curating like the best possible lawyer for you in your city. But yeah, like I said, just for a free consultation. So we're here to help. Just give us a text, and please like and subscribe to our channel. And feel free to comment and let us know what other videos you want to see, whether it's verdicts and settlements, whether it's a specific question you want answered, or whether you want to join us on the next live where we answer your questions live. Whatever you prefer, we are here for you. Okay, all the best and have a great night. Stay safe out there. Okay, bye-bye.